Question 1. A registered representative wishes to participate in a private securities transaction for compensation. Which of the following is required for the representative to proceed? A. Written notice to their firm, and the firm must approve the transaction in writing, recording it on its books and records. B. Written notice to their firm, and the firm must only acknowledge receipt of the notice. C. Oral notice to their firm, followed by written confirmation of the transaction after execution. D. No notice to the firm is required if the transaction is executed through an unaffiliated broker-dealer. Answer: A. Written notice to their firm, and the firm must approve the transaction in writing, recording it on its books and records. When a registered representative wants to engage in a private securities transaction, often called selling away, for compensation, FINRA Rule 3280 mandates that they must provide prior written notice to their firm and receive written approval before participating. The firm is then obligated to record the transaction on its books and records and supervise it as if it were its own business. This stringent requirement ensures proper oversight and prevents undisclosed conflicts of interest or unregistered offerings, protecting both the firm and investors. For example, if a representative wants to sell shares of a startup company privately for a commission, their firm must approve and supervise that activity. Remember, written notice and written approval are key for compensation-based private securities transactions. Question 2. A registered representative is promoting a new structured product to retail customers. As the Series 24 principal, which of the following is the most critical consideration for your supervision of this activity? A. Ensuring the representative has completed all firm element continuing education modules. B. Confirming the product's performance aligns with the issuer's projections. C. Verifying the representative has a reasonable basis to believe the product is suitable for the customer and that the customer understands its risks. D. Reviewing the customer's complete financial portfolio to identify any potential overconcentration. Answer: C. Verifying the representative has a reasonable basis to believe the product is suitable for the customer and that the customer understands its risks. For complex products like structured products, the suitability obligation under FINRA Rule 2111 is paramount, requiring the principal to ensure the representative has a reasonable basis to recommend the product and that the specific customer understands its unique risks. This involves both reasonable basis suitability, the product is suitable for some investors, and customer-specific suitability, the product is suitable for this particular investor. While reviewing a customer's overall portfolio for overconcentration is important for customer-specific suitability, the core concept of ensuring the representative's understanding and proper disclosure of risks to the customer is the most critical supervisory role regarding complex products. Always prioritize the customer's comprehension of complex investment risks. Question 3. Under FINRA Rule 4530, a member firm must report to FINRA a statistical and summary information regarding customer complaints on a quarterly basis. Which type of complaint requires immediate reporting to FINRA, regardless of the quarterly filing? A. A complaint alleging a minor clerical error that resulted in a small loss. B. A complaint alleging theft or forgery of funds or securities. C. A complaint concerning a delay in account transfer processing. D. A complaint regarding an unauthorized trade with no monetary loss. Answer: B. A complaint alleging theft or forgery of funds or securities. FINRA Rule 4530 outlines specific events that require prompt reporting to FINRA, generally within 30 calendar days of discovery. Among these, any customer complaint alleging theft or forgery, even if the amount is minor, is considered a serious breach of trust and requires immediate attention and reporting. While all complaints must be logged and potentially reported quarterly, allegations of criminal behavior like theft or forgery trigger a specific, expedited reporting requirement due to their severe nature and potential impact on public trust. Remember, allegations of financial crime demand urgent regulatory notification. Question 4. A new branch office is established by a broker-dealer. Under FINRA rules, what is the latest date by which the firm's supervisory system must conduct its first inspection of this new office? A. Within 90 days of the office opening. B. Within 6 months of the office opening. C. Within 12 months of the office opening. D. Within 18 months of the office opening. Answer: C. Within 12 months of the office opening. FINRA Rule 3110 requires a member firm to conduct an inspection of each Office of Supervisory Jurisdiction, OSJ, and branch office at least once every calendar year. For a newly established branch office, the firm's supervisory system must conduct its first inspection within 12 months of the office opening. This annual inspection ensures that the firm's supervisory policies and procedures are effectively implemented and maintained at all locations. For example, if a branch opens in March 2024, its first inspection must be completed by March 2025. Always remember that new offices, like existing ones, must undergo an inspection within their first calendar year of operation. Question 5. Which of the following is not typically considered a retail communication requiring principal pre-approval under FINRA rules? A. A brochure sent to 50 prospective clients describing a new mutual fund. B. A public seminar presentation script distributed to 200 attendees. C. A personalized email sent to a single existing client discussing their portfolio performance. D. A website page accessible to the general public promoting the firm's services. Answer: C. A personalized email sent to a single existing client discussing their portfolio performance. Under FINRA Rule 2210, retail communication is defined as any written, including electronic, communication distributed or made available to more than 25 retail investors within any 30 calendar day period. A personalized email sent to a single existing client discussing their portfolio performance falls under the definition of correspondence, which typically requires post-use review and supervision, but not necessarily principal pre-approval. In contrast, brochures, public seminar scripts for many attendees, and public website pages are designed for a broad audience and clearly meet the retail communication definition, thus requiring principal pre-approval before use. Differentiating between communication types is crucial for proper supervisory review. Question 6. A registered representative plans to volunteer their time to a local nonprofit organization as its treasurer, handling all financial records and banking. This activity is uncompensated. Under FINRA rules, what is the representative's obligation regarding this outside business activity, OBA? A. No notification is required as it is uncompensated and not securities related. B. Oral notification to the firm's compliance department is sufficient. C. Written notice to the firm is required, but the firm's approval is not. D. Written notice to the firm is required, and the firm must determine if it will approve or disapprove of the activity. Answer: C. Written notice to the firm is required, but the firm's approval is not. Under FINRA Rule 3270, an associated person who intends to engage in an outside business activity, whether compensated or uncompensated, must provide prior written notice to their member firm. The key distinction for uncompensated OBAs is that while written notice is required, the firm's approval is generally not. The firm still needs to know about the activity to determine if it interferes with the representative's duties, creates a conflict of interest, or appears to be a securities transaction. For example, acting as a volunteer treasurer requires notice because it involves handling funds and could pose a reputational or conflict risk. Always provide written notice for any outside business activity, compensated or not. Question 7. A member firm discovers that one of its associated persons has been sanctioned by a securities regulator for violating securities laws. Under FINRA Rule 4530, what is the firm's reporting obligation regarding this event? A. The firm must report this event to FINRA within 30 calendar days of discovery. B. The firm must report this event to FINRA on its next quarterly statistical filing. C. The firm has no reporting obligation as the associated person, not the firm, was sanctioned. D. The firm must report this event to the SEC, not FINRA. Answer: A. The firm must report this event to FINRA within 30 calendar days of discovery. FINRA Rule 4530 mandates that a member firm promptly report to FINRA, generally within 30 calendar days of discovery, certain events involving the firm or its associated persons. This includes any disciplinary action taken by a securities regulator against an associated person, particularly if it results in a suspension, bar, fine exceeding a specified threshold, or other significant sanction. The firm's reporting obligation ensures that FINRA is aware of regulatory actions involving individuals employed by its member firms, allowing for proper oversight and enforcement. For instance, if a representative is fined $5,000 by a state securities board, the firm must report it to FINRA within 30 days. Don't forget that disciplinary actions against associated persons are critical firm reporting requirements. Question 8. Under SEC Rules 17a(3) and 17a(4), a broker-dealer must retain certain books and records for specific periods. What is the minimum retention period for blotters and customer account records? A. 2 years. B. 3 years. C. 5 years. D. 6 years. Answer: D. 6 years. SEC Rule 17a(4) specifies the minimum retention periods for various books and records. Blotters, which are records of original entry for transactions, and customer account records, such as new account forms, suitability information, and account statements, must be preserved for a minimum of 6 years. These records are fundamental to reconstructing a firm's business activities and demonstrating compliance with regulations. For example, if a customer opened an account in 2018, the firm must keep those new account records until at least 2024. Remember that records like blotters and customer accounts are subject to a 6-year retention rule. Question 9. A registered principal responsible for approving retail communications is reviewing a new advertisement that contains a testimonial. What specific condition must be met for this testimonial to be permissible under FINRA Rule 2210? A. The testimonial must only be from an institutional client, not a retail client. B. If the testimonial concerns investment advice, the advisor must have been paid. C. The communication must disclose if the person giving the testimonial is compensated, and if so, whether they are a securities professional. D. The testimonial must be from a client with at least 5 years of experience in investing. Answer: C. The communication must disclose if the person giving the testimonial is compensated, and if so, whether they are a securities professional. FINRA Rule 2210 permits the use of testimonials in retail communications but imposes strict conditions to prevent misleading impressions. A key requirement is that if the person providing the testimonial is compensated, that fact must be clearly disclosed. Furthermore, if the testimonial concerns investment advice, the communication must also disclose whether the person is a securities professional. This transparency ensures that investors are aware of any potential bias or expertise level behind the testimonial. For example, if a client is paid $500 for their positive testimonial, the advertisement must state, "This client was compensated for their testimonial." Always disclose compensation for testimonials. Question 10. Which of the following describes the primary purpose of FINRA's Code of Procedure? A. To resolve monetary disputes between member firms and public customers. B. To establish rules of fair practice for member firms and associated persons. C. To outline the disciplinary process for violations of FINRA rules or federal securities laws. D. To govern the process for filing new membership applications with FINRA. Answer: C. To outline the disciplinary process for violations of FINRA rules or federal securities laws. FINRA's Code of Procedure is the mechanism for addressing alleged violations of FINRA rules or federal securities laws by member firms and associated persons. It outlines the formal disciplinary process, including complaint filing, hearings, appeals, and sanctions. Unlike the Code of Arbitration, which handles monetary disputes, or rules of fair practice, which set behavioral standards, the Code of Procedure details how FINRA enforces those standards through disciplinary actions. For instance, if a representative is accused of unsuitable recommendations, the Code of Procedure governs the formal steps of their potential disciplinary hearing. Remember, the Code of Procedure is about enforcing rules and administering discipline. Question 11. A registered representative engages in front-running. Which of the following best describes this prohibited activity? A. Trading a security in a customer's account excessively to generate commissions. B. Placing a personal order for a security with advance knowledge of an impending customer order that will likely affect the market price. C. Executing a customer order at a price inferior to what could have been obtained. D. Misrepresenting a security's characteristics to induce a customer to purchase it. Answer: B. Placing a personal order for a security with advance knowledge of an impending customer order that will likely affect the market price. Front-running is a prohibited trading practice where a broker-dealer or an associated person trades a security for their own account, or a discretionary account, with advance knowledge of a pending customer order of sufficient size to likely move the market. This allows the individual to profit from the anticipated price change at the expense of the customer or market fairness. For example, if a firm receives a large institutional order to buy 1 million shares of XYZ stock, and a broker places a personal buy order for XYZ shares before the institutional order is executed, that is front-running. This practice is distinct from churning, excessive trading, poor execution, or misrepresentation. Always ensure personal trades do not exploit knowledge of pending customer orders. Question 12. Under FINRA Rule 3110, an Office of Supervisory Jurisdiction, OSJ, must be managed by A. A Series 7 licensed individual. B. A Series 24 licensed principal. C. Any registered representative with at least 5 years of experience. D. A FINRA-approved financial operations principal. Answer: B. A Series 24 licensed principal. FINRA Rule 3110 requires that each Office of Supervisory Jurisdiction, OSJ, be managed by a qualified principal, meaning an individual holding a Series 24 license, General Securities Principal, or another appropriate principal qualification. An OSJ is a location where critical supervisory functions are performed, such as order execution, approval of new accounts, and review of customer communications. Therefore, a Series 24 principal is essential to ensure proper oversight of these activities. For example, a branch office where customer orders are accepted and reviewed must have a Series 24 principal overseeing its operations. Always associate OSJs with the requirement for a Series 24 principal. Question 13. A broker-dealer's anti-money laundering, AML, compliance officer must be approved by A. The firm's CEO. B. The firm's board of directors. C. FINRA. D. No specific approval is required beyond being identified by the firm. Answer: D. No specific approval is required beyond being identified by the firm. Under the Bank Secrecy Act and FINRA rules, a member firm must designate an individual responsible for implementing and monitoring its AML compliance program. While this individual, the AML compliance officer, must be a qualified person, there is no specific regulatory requirement for FINRA or any other external body to approve this designation. The firm itself identifies and designates the individual. However, the firm must provide FINRA with the name, title, mailing address, email address, and phone number of the designated AML compliance officer. The key is internal designation and reporting, not external approval. Question 14. When a customer initiates a transfer of an account from one member firm to another, which FINRA rule governs the process and disclosures provided to the customer by the carrying firm? A. FINRA Rule 2090, Know Your Customer. B. FINRA Rule 2273, Disclosure of FINRA Broker Check. C. FINRA Rule 2111, Suitability. D. FINRA Rule 2273, Customer Account Transfer Disclosures. Answer: D. FINRA Rule 2273, Customer Account Transfer Disclosures. FINRA Rule 2273, titled Customer Account Transfer Disclosures, specifically addresses the obligations of the carrying firm, the firm from which the account is being transferred, when a customer decides to move their account to another broker-dealer. This rule requires the carrying firm to provide specific disclosures to the customer regarding potential fees, assets that may not be transferable, and other important information related to the transfer process. This ensures transparency and helps customers understand the implications of moving their accounts. The other rules listed cover different aspects of customer relationships or disclosure. Question 15. A Series 24 principal is reviewing the firm's Business Continuity Plan, BCP. Which of the following is an essential component of a robust BCP that must be reviewed annually? A. A detailed list of every customer's primary and secondary financial objectives. B. Identification of mission-critical systems and a plan for their backup and recovery. C. A comprehensive log of all retail communications approved in the past year. D. The firm's annual audit report from its external accounting firm. Answer: B. Identification of mission-critical systems and a plan for their backup and recovery. A firm's Business Continuity Plan, BCP, is designed to address how the firm will respond to significant business disruptions and ensure that essential operations continue or can be resumed promptly. A crucial element of an effective BCP, as required by FINRA Rule 3110-C, is the identification of mission-critical systems, e.g., trading platforms, data storage, and specific plans for their backup and recovery, including alternative communication and processing channels. The BCP must also be reviewed at least annually by a principal. Customer objectives and retail communication logs are not direct components of the BCP, and audit reports, while important, are distinct from the BCP itself. Always ensure your BCP can restore critical operations quickly after a disruption. Question 16. Under FINRA Rule 3220, a member firm and its associated persons are generally prohibited from giving anything of value in excess of a specified annual limit to any person associated with another member firm, where such payment is in relation to the business of the recipient's employer. What is the annual dollar limit for gifts and gratuities? A. $50. B. $100. C. $250. D. $500. Answer: B. $100. FINRA Rule 3220, the Gifts and Gratuities Rule, generally prohibits any member firm or associated person from giving anything of value in excess of $100 per year to any person where such payment is in relation to the business of the recipient's employer. This rule is designed to prevent undue influence or perceived kickbacks among firms and their employees. For example, a broker-dealer cannot send an employee of another firm a holiday gift basket worth $150. Exceptions exist for legitimate business entertainment, but direct gifts are capped at $100. This rule helps maintain fairness and ethical conduct in the securities industry. Question 17. A firm's research analyst issues a research report covering a company for which the firm recently acted as lead underwriter in an IPO. During what period after the effective date of the IPO registration statement is the firm generally prohibited from issuing a research report or making a public appearance concerning the issuer? A. 10 calendar days. B. 25 calendar days. C. 40 calendar days. D. 90 calendar days. Answer: C. 40 calendar days. Under FINRA Rule 2241, research analysts and research reports, a member firm that has acted as manager or co-manager of an initial public offering, IPO, is generally prohibited from publishing research or making a public appearance regarding that issuer for 40 calendar days following the effective date of the IPO. This quiet period is designed to prevent the appearance of research being influenced by the underwriting relationship and to allow a period for the market to stabilize without firm-sponsored promotion. For example, if an IPO goes effective on January 1st, the firm cannot publish research until February 11th. Remember, IPOs have a 40-day quiet period for research by the underwriting firm. Question 18. A registered representative receives an oral complaint from a customer alleging unauthorized trading in their account. What is the Series 24 principal's primary responsibility regarding this complaint? A. To immediately file a report with FINRA, regardless of the complaint's validity. B. To dismiss the complaint if it is not received in writing within 24 hours. C. To investigate the complaint promptly and thoroughly, regardless of whether it was oral or written. D. To advise the customer to pursue the matter through arbitration. Answer: C. To investigate the complaint promptly and thoroughly, regardless of whether it was oral or written. FINRA Rule 3110, A. 8, requires member firms to maintain a record of all written customer complaints, and while the rule specifically mentions written complaints, firms are generally expected to handle all complaints, whether oral or written, in a serious manner. The principal's primary responsibility is to ensure the complaint is promptly and thoroughly investigated to determine its validity and take appropriate action. Dismissing an oral complaint, immediately reporting without investigation, or directing a customer to arbitration are not initial primary responses. Every customer complaint, regardless of its form, demands a diligent investigation. Question 19. Under Regulation SP, a broker-dealer must provide an initial privacy notice to customers. A. Only upon written request from the customer. B. Annually, along with the firm's annual report. C. At the time the customer relationship is established and annually thereafter. D. Only if the firm shares non-public personal information with non-affiliated third parties. Answer: C. At the time the customer relationship is established and annually thereafter. Regulation SP, Privacy of Consumer Financial Information, requires broker-dealers to provide an initial privacy notice to customers at the time a customer relationship is established. This notice explains the firm's policies regarding the protection of non-public personal information. Furthermore, the firm must provide an updated privacy notice to customers at least annually thereafter. This applies whether or not the firm shares information with non-affiliated third parties. For example, a customer opening a new account in January must receive the privacy notice then, and again every January thereafter. Always remember that privacy notices are required both at account opening and annually. Question 20. A broker-dealer wants to market a new proprietary mutual fund. Before the fund can be offered to the public, which of the following is required from the firm's perspective? A. The firm must wait for FINRA to pre-approve the fund's offering circular. B. The firm must establish a reasonable basis suitability determination for the product. C. The firm must obtain a guarantee from the fund's portfolio manager regarding minimum returns. D. The firm must solicit expressions of interest from at least 100 potential investors. Answer: B. The firm must establish a reasonable basis suitability determination for the product. Before offering any new product or service, including a proprietary mutual fund, FINRA Rule 2111, suitability, requires a member firm to conduct a reasonable basis suitability determination. This means the firm must perform adequate due diligence to understand the product's characteristics, risks, and rewards, and then determine that the product is suitable for some investors. This foundational suitability assessment must occur before the firm can even begin to recommend the product to individual customers. FINRA does not pre-approve offering circulars, guarantees are prohibited, and soliciting interest from specific numbers of investors is not a prerequisite for the firm's initial due diligence. Ensure your firm understands a product's suitability before marketing it. Question 21. Which type of communication is generally exempt from FINRA's filing requirements, even if it is a retail communication? A. An institutional communication. B. An independently prepared reprint. C. A correspondence. D. A tombstone advertisement. Answer: D. A tombstone advertisement. While most retail communications require principal approval and potentially FINRA filing, a tombstone advertisement is specifically exempted from FINRA's filing requirements. Tombstone ads are very limited in their content, only stating basic facts about a securities offering, such as the issuer, type of security, public offering price, and names of the underwriters. Because their content is so restricted and factual, they are generally considered not to be promotional and therefore do not require FINRA filing. Institutional communications and correspondence are typically not subject to filing because of their limited audience, but tombstone ads are exempt based on their content and purpose. Remember, tombstone ads are basic and filing exempt. Question 22. A registered representative has an outside business activity, OBA, that generates compensation. Under FINRA Rule 3270, the firm determines that the OBA is a passive investment in a family real estate partnership. What is the firm's supervisory obligation regarding this OBA? A. The firm must approve the activity in writing and supervise it as if it were firm business. B. The firm must only keep a record of the written notice, as it's a passive investment. C. The firm has no supervisory obligation since it's a passive investment and not securities related. D. The firm must prohibit the representative from engaging in this OBA. Answer: B. The firm must only keep a record of the written notice, as it's a passive investment. FINRA Rule 3270 requires associated persons to provide prior written notice to their firm for any outside business activity. If the firm determines, based on this notice, that the OBA is a passive investment, e.g., a limited partnership interest or direct real estate investment where the associated person does not materially participate in the business, the firm's supervisory obligation is significantly less stringent. For passive investments, the firm is generally only required to acknowledge receipt of the written notice and keep a record of it. Active supervision or approval is not required. This is a key distinction from other OBAs or private securities transactions. Passive investments typically require only written notice and record keeping by the firm. Question 23. An individual is seeking to register as a General Securities Principal, Series 24. Which of the following is a prerequisite for taking the Series 24 exam? A. Holding a Series 7 license. B. Holding a Series 63 license. C. Having at least 5 years of experience in the securities industry. D. No specific prerequisite licensing exam is required. Answer: A. Holding a Series 7 license. To qualify as a General Securities Principal, Series 24, an individual must first hold at least one of the following General Securities Representative registrations: Series 7, General Securities Representative; Series 79, Investment Banking Representative; Series 62, Corporate Securities Representative; Series 17, Limited Securities Representative, CIE, for certain European representatives, or Series 3738, Limited Securities Representative, U.S. Government Securities and Investment Company/Variable Contracts Products. The Series 7 is the most common prerequisite. This ensures that a principal has a fundamental understanding of the securities business before supervising others. For instance, an individual cannot simply pass the Series 24 without first demonstrating their knowledge as a representative. Always remember that a representative-level exam is a prerequisite for principal qualification. Question 24. A member firm is developing a new algorithm for its high-frequency trading desk. As the Series 24 principal, your supervision of this development should primarily focus on A. Maximizing the algorithm's profitability. B. Ensuring the algorithm complies with market access rule requirements and prevents manipulative trading. C. Obtaining pre-approval from all major exchanges for the algorithm's use. D. Confirming the algorithm's code is proprietary and cannot be reverse engineered. Answer: B. Ensuring the algorithm complies with market access rule requirements and prevents manipulative trading. When supervising the development and use of high-frequency trading algorithms, the Series 24 principal's paramount responsibility is to ensure compliance with regulatory requirements, particularly those related to market access, e.g., SEC Rule 15c3-5, and anti-manipulation rules. This includes establishing controls to prevent erroneous orders, excessive messaging, and disruptive trading practices, as well as detecting and preventing market manipulation. While profitability and proprietary concerns are business objectives, regulatory compliance and market integrity are the core supervisory duties. For example, the principal must confirm the algorithm has pre-trade risk controls embedded to prevent orders that would exceed credit limits or pose immediate market risk. Compliance and market integrity are paramount when supervising automated trading systems. Question 25. Under FINRA Rule 3110(c), a member firm is required to have a written business continuity plan, BCP. Which of the following statements regarding the BCP is true? A. The BCP must be filed with FINRA for approval prior to implementation. B. The BCP must be made available to customers upon request. C. The BCP must be updated quarterly to reflect market changes. D. Only OSJs are required to maintain a BCP, not smaller branch offices. Answer: B. The BCP must be made available to customers upon request. FINRA Rule 3110(c) requires member firms to establish and maintain a written business continuity plan, BCP, designed to respond to significant business disruptions. A key requirement is that the firm must make its BCP summary available to customers upon request and post it on its website, or provide a written disclosure statement at account opening. This transparency ensures customers know the firm has a plan to continue operations and access to their accounts in a disaster. While BCPs must be reviewed at least annually, they are not typically filed with FINRA for approval, nor are they required to be updated quarterly, and they apply to the entire firm's operations, not just OSJs. Customers have a right to know their firm has a continuity plan.